So for him to take her order and go, what about you? What do you like? And you're just like, he knows what she likes. It is a wild thing to say, and it was not in the script, and it was crazy. When I found that in the edit, I was like, oh my God, why is this not in the movie? And then it became it was not just my favorite moment, but just everybody in that room was like that line. And then we started quoting it every time we ordered lunch. It was like, you know, I'm getting this, I'm getting the yuzu salmon.
What about you like?
Sweet greens, what about you?
Hi, besties. Blake Lively talked to herself in court via her shell company, and her shell company's attorneys talked to her attorneys. So Blake spoke to herself in court filings and acted like they weren't the same person. Blake Lively is hiding behind a shield that's called Vanzan Inc., a company that filed a lawsuit in September of 2024 against no one in the state of New York in the Supreme Court of New York County. And in that lawsuit, she subpoenaed Stephanie Jones and Jones Works for all the records and data from Jen Abel's phone. And through that process, no one was notified. There was no documents or other records. The lawsuit made no sense, and it had nothing to do with sexual harassment. And Jen Abel had no ties whatsoever to Vanzan Inc. And now Jen is trying to get a hold of a copy of the subpoena, along with a copy of all of the records that she sent to Jones Works, along with communications with Jones Works and information about the company itself. And now we know why Blake Lively set up the protective order in this case and why she made it so incredibly hard in this case to file discovery and to access discovery. It appears as though Blake Lively is playing a game, manipulating the court, and her lawyers are playing this game as well. And the protective order has a confidentiality clause, and if you deem something confidential, you have to sign a non-disclosure agreement. So you, one, can't tell anyone that you've signed it. If you use it, you can't share it, and it can only be used in the action that the discovery is filed. And so Blake was taunting Jennifer Abel by filing a document telling her, hey, we already provided you a copy of this discovery. It's over here in an action that has nothing to do with you. And here, there's a subpoena over here, but some of this stuff is marked confidential. And by the way, even though it's marked confidential and you have it, you can't use it. And so so when she went to the court to compel, she told the court, this is her shell company. We need this information. It's all right. This was the means that they used to get this discovery. Her attorneys have admitted they used this lawsuit to get this discovery. And now the attorneys that represented Vanzan have hired, like Vanzan's hired an outside counsel outside of Manat, which tells me something fishy went on, right? Why does Vanzan suddenly need a different attorney? Vanzan was once represented by the same company, the same law firm that's representing Blake. And now they're pretending like they know nothing about this litigation. And to see this play out in court, it's almost diabolical. It feels, in a way, sadistic to me. And I do not at all envy the people that are on the receiving end of this, because it's abusive. And if the judge even buys this for a minute, I will have no faith in Judge Lyman. If he even entertains this, out the window is any faith or hope that there could ever be justice in this case. This is the most blatant abuse of the court I've ever seen. It's abusive in that it's trying to conceal the identity, because on the one hand, Blake says, here is the evidence. But then on the other hand, Blake, through her company, is saying, you can't have it. Here's the letter that they filed. And they're acting like Jen Abel is dumb. And they were accusing Jen Abel and Wayfarer of using this for publicity. Again, using that tired excuse they've been using for how long? Okay, so the motion appears to be yet another attempt by Abel and Wayfarer parties to use this legal proceeding to continue their negative media campaign against Blake Lively and her associates. this time by seeking documents from a third party that Abel already possesses or are irrelevant to any claims or counterclaims in this litigation. And the only justification Abel offers is the Wayfair party's time-worn argument that there was something improper with respect to the Doe lawsuit Vanzan filed in New York State Court, which uncovered scathing evidence of Abel and the Wayfair party's retaliation campaign against Miss Lively. Vanzan doesn't tell the court why they opened this lawsuit. They don't share why it was opened. But Abel offers no legal or factual support for this argument because there is none. What's more, Abel attempts to mislead the court by suggesting that two of the subsets of documents she requests, the subpoena issued by Vanzan and the corresponding produced documents, are not fully in her possession when she knows that they are. Letter from the counsel for Miss Lively. So this is literally Blake Lively talking about Blake Lively, and that Vanzan has somehow uncooperative when in truth Miss Abel abandoned the meet and confer process and filed the motion out of the blue after no communication for 3 weeks. Out of the blue. She's always the victim. This motion should be denied for two principal reasons. Abel has already received the only potentially relevant documents, the underlying materials produced in response to the Doe subpoena, and the remaining requests have zero relevancy to any claims or counterclaims in this litigation, are moot, or should be obtained from other parties. However, as set forth below, to expedite this litigation and reduce the burden on the court caused by Abel's unnecessary motion practice and abandonment of the meet and confer process, Vanzan will voluntarily agree to produce documents responsive to numbers 10 and 11, even though she already has them, and to requests 1 and 4 based on her narrowed requests as articulated in the motion to the extent described below. The motion should be denied as moot as to requests 1, 4, 10, and 11, and as to request 9, which seeks communication between Vanzan and its counsels and Stephanie Jones and Jones Works and or their counsel concerning the Doe lawsuit, Abel should obtain those documents directly from Ms. Jones before burdening third-party Vanzan. They just used the same argument with 2 of the employees from TAG, and he said that they could get it from those employees. So I don't know if he doesn't rule that the same. Again, I'll have no faith in Judge Lyman. As an initial matter, the motion is notable for what Abel omits from it. Abel fails to inform the court that she abandoned the meet and confer process, so she's blaming Abel. And Vanzan highlighted its various objections to the subpoena. Nevertheless, to resolve the dispute without the court's involvement, we offered to produce 2 of the items that she now seeks, specifically the Doe subpoena served on Stephanie Jones in the New York litigation and the documents produced by Ms. Jones in response. Vanzan confirmed this proposed solution via email on May 30th and offered to further confer. Counsel for Vanzan did not receive a response to this email, even though by that time she had already received production of the subpoena and responsive documents over a week before that. 3 weeks later, she filed this motion without any notice to Vanzan, obscuring the fact that she already had the documents in her possession. The problem is that she didn't really have the documents because there was a protective order on them, right? Abel's motion should be denied because she fails to demonstrate how the documents are relevant to the claims or counterclaims in this litigation. She needs to know that it was a shell company. She needs to actually have proof for the court. Abel has a far-fetched theory that the documents are relevant to her amended counterclaims. Abel's amended counterclaims, of course, are currently subject to a pending motion to dismiss. Do you remember how I told you that they're delaying all of this in the hopes that their biased judge, who's clearly already picked a side, will not take into account what Jen Abel went through and just dismiss the case? They truly believe that they've won in this court, and it's clear that they believe that this judge is on their side, and that if they just wait this out, nobody has to know about the Vanzan Inc. lawsuit, which, if granted, would eliminate the issues in this motion entirely. So reminding the court, like, you should she's like intervening to tell them you should dismiss Abel's case against Jones Works. Abel's counterclaims are at heart an employment dispute with her former employer, Miss Jones, and have nothing to do with Vanzan. So if Jen Abel's phone and the contents of her phone have nothing to do with Vanzan, then why does Vanzan have the contents of her phone? I am starting to believe that they crafted this scheme where Blake, on the one hand, would sue them, Wayfair, and then on the other hand, Stephanie would file suit against Jen and Melissa so that they both make it look like this side is the bad side, right? And make this court make it look like Wayfair are the enemies and they've done this bad thing, even though these are the two that did the bad thing to Wayfair. That's why it's a scheme. I have a hard time believing that this wasn't coordinated. Vanzan had nothing to do with Jen Abel. Then Jen Abel didn't need her phone from her previous employer. And it again points out that Blake is going to take no ownership for the fact that Stephanie may have stolen the data. She's going to place all of the blame on Stephanie Jones. The claims arise from events Abel has occurred when she was terminated and her cell phone was obtained by her employer in August 2024. Events in which Vanzan is not alleged to have been involved in any way, and which took place weeks before the Doe lawsuit was initiated. How did you know, Vanzan, how to get the phone if you knew nothing about it? How did you know to go to Stephanie Jones for the phone? Moreover, the requests also seek documents that are appropriately sought from Plaintiff Jones or other parties in the litigation, which Jen's already told the court she's refused to produce. Vanzan is not party to any litigation involving Miss Lively and the Wayfair parties. Blake Lively is using the contents of Vanzan's subpoena, and Vanzan has the audacity to tell the court they're not party to any litigation. When her attorneys said that it's not uncommon to use a company to shield your identity. So Blake is saying Blake is not party to anything. It's just a loophole she's using, and she's gaming the court because everyone knows Vanzan is Blake. Abel already received the Doe subpoena and documents from Miss Lively, a party to the related litigation with Abel. And any communications involving Miss Jones, to the extent they exist, should be obtained through her document requests Abel has made to Jones, who she will deny, right? Ultimately, this motion is consistent with Abel and her counsel's pattern of using the court's docket to advance public relations narratives in the media. So there's no legitimate purpose whatsoever for Miss Abel seeking valid discovery. It's only for PR. If that were not their goal, Abel would have continued the meet and confer process, or at least responded to Vanzan's May 30th email and informed the court that she in fact possessed the information she now seeks. To the extent she maintains that she should receive a second copy of these materials so that she can confirm information she already has, then Vanzan agrees to reproduce those materials as previously offered. In addition to help resolve the dispute without further burdening the court, the Vanzan will produce its articles of incorporation, which are publicly available, and written consents of Vanzan boards of directors, which reflects its officers and shareholders to satisfy requests 1 and 4. And as for request 9, any responsive communications with Jones and Jones Works, to the extent that they exist, would be in possession of Miss Jones. And they asked them to deny this because it's moot. This is such an abusive letter. They actually attached a copy of emails that they had sent back and forth. And during the May 30th email, this is what they shared. During the meet and confer, you expressed that you were unable to confirm whether you have received any of the Doe subpoena and produced documents due to the operative protective order in the Lively litigation. You offered to review the protective order and determine what information you can disclose regarding your receipt of the documents, so you can confirm to us whether you have already received the subpoena and produced documents. Of course, we would be willing to enter into an agreement that would protect that information, including agreeing to the terms and conditions set forth in the protective order. So Vanzan was demanding that they tell them if they have this information. And they said, well, we have a protective order and we don't know. First of all, not everyone can see what's in this discovery. Some of the lawyers can, right? But if some of them are marked as confidential, they can't be shared into Jen's case. So even though she sent them to Wayfair, if she marked any documents confidential, and she said she did, they can't be shared across cases. And then they're asking them, Wayfair, to break the protective order by telling Vanzan about what they have, which is obviously a violation of a protective order, which can mean contempt of court, which is in the protective order, is that if you provide this information to people you're not supposed to, you can be placed in contempt. And he said he would have no problem filing contempt charges. And then in their objections to the subpoena, which they sent and were in the attachments, they try to act like this entire lawsuit was completely justified. And then they deflect and they tell Jennifer Abel that the only reason she's doing this is to deflect from what she did to Blake. The vast majority of documents sought have no relevance to this action. To the extent defendant Abel seeks subpoenas issued and materials produced in the lawsuit, namely Miss Abel's own communication, she already possesses those or can access them through less intrusive means via discovery propounded to the parties to this action and related matters. It's pretty evil and really despicable to tell her that Jen has access to her communications when we know she doesn't. Her entire phone was stolen. And as such, the subpoena appears to be nothing more than an effort to deflect from the fact that the defendant's communications evidence her orchestration and aiding and abetting of a campaign to spread false information about Miss Lively and portray her in a false light in retaliation for raising concerns about sexual harassment on the set of a film. I actually saw a lot of the communications of what Jen was talking about behind the scenes, and I didn't see her spreading a false campaign of false information. She was doing a lot of encouraging of Justin and trying to like keep him positive, help him through this, motivated, telling him to just like get through it. It'll be so, I know it's hard, but keep going. I didn't see her planting stories. I didn't see her besides calling Blake, the C word, and I don't even know if she did or if that was Melissa, which maybe she was being a C word, I don't know. But, first you'd have to believe that sexual harassment happened and we don't. And second, you'd have to believe that the smear campaign or the retaliation, quote unquote, was because of her raising concerns and not because they were spreading false allegations against them. And that Justin was dealing with severe threats constantly from Reynolds and from Blake. But no, just blame her for committing the crime against you. So it's like they actually decided this was a smear campaign before anybody ever hired Melissa. So they were already planning to use this theory, right? Based on all the evidence we've seen so far. Melissa's on the team for like a week, and then they're accused of starting a smear campaign because that was what they were going to go with. And then they've put together evidence to prove that they've started the smear campaign, ignoring everything else that happened in real life and Blake's own words. And then Stephanie, is the one that commits the crime of like, not the crime. I don't even know if it's a crime. Well, Jen says it's a crime, but she accesses Jen's private data, hands it over to Leslie. Leslie tells Melissa Nathan she's going to get sued in August, right? Leslie should have not been able to see anything that was in Jen's phone at all because there was a confidentiality agreement between Stephanie Jones and Wayfarer, and there was confidentiality agreement between Jones and Abel. But for whatever reason, she's handed it all over to Leslie to get out of her own crap where she was planting stories. Now, to make matters even more interesting, Stephanie Jones is now seeking information from Meta and from Pinterest to identify the identity of the people that are behind the Stephanie Jones leaks Facebook and Pinterest pages. And Pinterest and Meta are not complying and they've objected. And so now she's compelling them to disclose who these people are. And she claims that somehow in the around of it all, that two of Melissa Nathan's employees were behind all of that. I don't know if that's true or not, but lots of people have pages that are negative about them. I mean, there's people that create whole channels about me. And I don't know that some of the things that she claims are defamatory are actually defamatory. So the bio for the Pinterest account falsely states Stephanie Jones is known to leak information about her clients to the press so she can save the day for them and inspire their gratitude. Okay. I don't know that that's actually defamatory. And the Facebook falsely states Stephanie Jones serves legal letters based on trumped up claims. She resorts to threats both personal and professional. She says that's a false one. I will tell you, I received a legal letter from Stephanie Jones that was based upon false, trumped up claims that have no basis in reality. And that's not actually it's not defamatory. And if it's true, it's not defamatory. And that also appears to be an opinion. You don't always have to say, it's my opinion in front of everything. Some opinions are implied. She tells the court that Brianna Coslow and Catherine Case served vague objections that the subpoenas, which seek only information regarding who created the false and abusive Facebook and Pinterest accounts, and by extension, the website, called for their personal information. So the Facebook page has that one tagline, and there's nothing else posted there. And then the Pinterest page also has one tagline and nothing's posted. And by extension, the websites. So they're claiming that Melissa is behind the Stephanie Jones leaks website. Miss Koslow and Miss Case are or have been employees of the agency group PR, public relations agency run by Melissa Nathan, a party in the underlying suit who has denied knowledge of who created the profiles or websites. Miss Case was an employee of Jones Works prior to being hired by the agency group, and counsel for Miss Butler and Miss Case would not confirm or deny whether they created the profiles and websites. So because she has a hunch that these two people are behind it, because here's how it works. If Meta gets a subpoena and it's seeking information from your account, generally they will contact you and let you know that a subpoena has been issued or ordered and that your information might be disclosed, unless they don't have to tell you in cases of like child exploitation. But in a case like a civil case, they might notify you. Now, Stephanie is trying to link Justin Baldoni into a months-long conspiracy to attack and defame Jones and Jones Works. Mind you, in the article that was published on Business Insider, they claim that they spoke to like dozens of people, former and a couple current employees, and then former clients. So it wasn't just 3 people behind the scheme or 4 people. And if everyone has the same experience, whether it's, you know, negative for you or not, that's their experience. But she says that they secretly conspired for months to publicly and privately attack her and defame them and breach contracts and steal clients and business prospects. Then she goes on to say that Baldoni feared that the allegations of his misogynistic and toxic behavior on set would become public and damage his reputation and career. Well, that's weird. I thought it was sexual harassment. I thought it was sexual harassment and sexual misconduct. Now it's misogynistic and toxic. It's interesting how they're starting to frame things differently. Baldoni and Wayfarer's CEO Jamie Heath turned to Abel, who at the time was an employee of Jones Works and had become to the point person on the Baldoni and Wayfarer account. Abel then brought on defendant Nathan, a crisis fixer, against the express instructions of Jones. And then Abel and Nathan, with Heath's encouragement, worked to shut out Jones of the process and hide their strategy. And that's not true. She was copied on everything. Abel and Nathan schemed to bury and destroy Baldoni's co-star in order to protect Baldoni. This was concealed from Jones and far outside the scope of her employment. Not true. She's trying to defend against the lawsuit that Abel filed against her. And then she claims that Abel and Nathan coordinated with Business Insider reporter Katie Warren, resulting in an August 2024 article titled "Who's Afraid of Stephanie Jones?" We don't know a lot of Melissa Nathan's background here, and we also don't know what her position is on all of this. We know that Jen Abel has told the court that she found out about the article through Stephanie Jones, not through Melissa Nathan. The article was highly critical of Jones and boosted the disparaging website Stephanie Jones Leaks, which had been posted by the John Doe defendants, accusing Jones of having a reputation for aggression and having been dropped by high-profile clients. I think those are true. Abel facilitated Warren outreach to Jones' former clients in order to further disrupt her business and negatively influence coverage. Abel and Nathan privately celebrated the publication of the article, which they referred to as a kill story. As her planned departure from Jones Works near, she boasted to Nathan about the damage she was doing to Jones Works, and Abel conspired to ensure that Baldoni and Wayfarer would leave Jones Works with her new planned firm. Here's the thing. If there's a lot of people that are having problems and you're being abusive, and a lot of clients have dropped you, and it's a matter of public interest that you are leaking information about clients and treating people badly, and you have a public platform and a public company, and you're a person that's speaking for other public officials, that's a matter of public interest. So whether or not it's a kill story is really irrelevant. If it's the truth, it's the truth. And she still to this day is not suing Business Insider. So the motion to compel is a whole thing. And she says that, Brianna and Katie, their attorneys responded and said that, they're objecting because it would provide personal information or something like that. But Stephanie Jones filed a declaration, which I think is hysterical because in the declaration, she says that she has been part of a big smear campaign to destroy her. And it's funny when someone who's in PR, who's spent their years planting stories about people and probably using similar techniques against people, then when it happens to her, it's a problem, allegedly. She says the website published long form exposés making false allegations about me. When the site was removed, the same content reappeared just days later on Stephanie Jones' Lies, which remained live until earlier this year. At the same time as the websites, multiple fake social media accounts were created that echoed the defamatory language of the websites and amplified links to them. Whenever we succeeded in having one account removed, another appeared under a new handle. So then she discusses the Facebook one and the Pinterest one and the website. But here's what she said. One of the fake social media accounts is a Facebook account bearing my name, Stephanie Jones. The profile falsely states that Stephanie Jones serves legal letters based on trumped up claims. She resorts to threats, both personal and professional. It falsely states that, but I got a legal letter based on trumped up claims. And then the other one, the Pinterest one, says Stephanie Jones is known to leak information about her clients to the press so she can save the day for them and inspire their gratitude. And she says that's false. But isn't it that she did spread information about Justin Baldoni during the process of when he was her publicist and handed over stuff to Blake Lively? And now afterwards, she's leaked the contents of Jen Abel's phone, which includes information about her former client Justin Baldoni and Wayfarer. So aren't they saying something about her that's true? So did she sue Justin to make it look like he did something that he didn't so that she could look like the victim of him, just like Blake? Kind of seems that way. These two are playing really gross games in the court. They're manipulating games. And listen, if PR agents and their affiliates are engaging in this kind of behavior, it's trashy, it's really disgusting, and I don't condone or support it in any capacity. I have had numerous pages created like this about me. I've never been able to get them taken down. They always spread defamatory information about me. There's whole Reddits about me that are false, but if you're going to be in this industry, you have to have a thick skin. And so if you can dish it, you better be able to take it. But if you're a company that's doing things for clients to try to destroy their people, or you're trying to destroy your client's life after they fire you, and this is what you're doing in the PR industry, that is the opposite of having integrity. And it's the opposite of acting professional. And none of this behavior from anyone is acceptable. That's my opinion. But in this case, even if they did create that, there is a thing called freedom of speech, and it's a right in the United States. So, what are your thoughts about all of this? Let me know in the comments below. Make sure to give this video a thumbs up. Make sure to subscribe to my channel if you haven't subscribed and click the bell so you never miss a video. Thanks so much for watching. Bye, guys.